Thanks for everybody joining us. I think we're going to be getting started. Are you guys ready?
Ready?
I'm ready.
Great. Well, I'd like to introduce Andrea, Kirshenbaum, and James Malone. They're with Schell. They will be presenting today some information on the Families First Corona Response Act. I ask that you please mute your line. We will be actively muting lines during the presentation and taking questions and answers at the end through the chat feature. And that being said, Andrea, I'll turn it over to you two.
Thanks very much, Hope. I'm going to kick us off. And my name is Andrea Kirshenbaum. I'm a principal at the law firm of Post & Schell and chair of the Wage and Hour Practice Group at the firm. And I have with me my colleague, Jim Malone, who is going to answer all questions and share with you his insight regarding the tax aspects of the Families First Coronavirus Response Act. So first, I'd like to say, obviously we're dealing with just an unprecedented situation. And I know you all, in trying to manage your businesses, are doing the best that you can. Our goal here is to provide you with concrete and specific suggestions as to how to navigate compliance with this law. And obviously, if you have any questions as we go through, please put your questions into the chat box and we will address them at the end of the presentation. I also wanted just to thank PRLA for inviting us to do this. And you all, I don't know how lucky you are, what a tremendous industry organization they are, and the amount of support that they give to you all. I just think it's tremendous. So without further ado, we're going to get into the meat of the presentation. Obviously, you all have heard that last week the Families First Coronavirus Response Act was passed, and really there were multiple provisions, but our focus today is really three of the provisions. The first is the amendments to the Family and Medical Leave Act. The second is the sick leave portion, and the third is the tax treatment of those two portions. So the effective date of the act is 15 days after it was enacted. So everyone, keep in the back of your mind that we're focused on April 2nd, which is next week. I've been, saying to people that I kind of feel like a dog, and I'm sure you guys do as well, like every day feels like a week. So April 2nd is just around the corner, but it's also pretty far away just in terms of the day-to-day of the challenges that we've been facing here. So both acts, and we'll talk about this throughout, but it's really important to emphasize that both, when I say both acts, I'm speaking of the FMLA amendment and the Sick Leave Act, only apply to employers with fewer than 500 employees. So we're going to talk a little bit as to what it means to be an employer under the FMLA portion first, but it's really important just to be focused on that. So obviously the question then becomes, who is an employer? And we've gotten a lot of questions since the passage of the act from our clients asking if there's like a management parent corporation that does a lot of the back office work and they're, less than 500, or each of the different entities are less than 500, but aggregated together they're over 500. So the question is, when can you aggregate and when can you not aggregate? Obviously, there's a whole lot of challenging news that we're facing on a day-to-day basis. The good news is that the United States Department of Labor is very engaged in the process here. They're actively trying to seek information from different stakeholders, and I'll show you later on how you can make your voice heard to the U.S. Department of Labor as they prepare and issue implementing regulations, emergency regulations to the act. So hopefully we're going to see some regulations in the next few weeks. Obviously, we'll have to wait and see. The period that the Department of Labor has given that they're seeking comments until is March 29th. So I certainly wouldn't expect anything until after then, and we may not see the regulations until after April 2nd. which is the effective date. So there may be some, blanks or spots that are going to have to be filled in by the U.S. Department of Labor as we go along here. Obviously, this is an incredibly dynamic situation, and so we're just going to do the best we can. And obviously, I would encourage you throughout to make sure that you're keeping, abreast of the situation with PRLA. So I think that given the circumstances as we have them today, March 24th, since the first part of the act is an expansion of the FMLA, an amendment to the FMLA, I think at this point, what we should be doing is looking to the definition of employer under the FMLA. Again, we may see DOL regulations in the next week that give us more clarity, but there are two tests that I've set out in the slides. One is the single employer test as to whether separate entities are going to be part of a single employer. And so I have also given you the sites of the regulation. So to determine whether separate entities are an integrated employer, you have to apply a multi-factor test, which is exactly what you want to hear under this circumstance. But the multi-factor test, it's 4 prongs. So you're going to look at whether there's common management as between 2 or more entities and whether there's an interrelation of operations. So if you have 7 restaurants and you have some servers or a lot of servers that work at multiple restaurants, that's going to be something you would want to look at. If there's one management company that has control over hiring and firing and those sorts of things, scheduling workers, and whether there's common ownership of the various restaurants or financial control. So you're going to want to try to figure out which entities can be aggregated to see whether you reach that 500 number or you don't. I also put up here the second test, which is a joint employer test. So let's say you have 2 different restaurants and they share workers, but there is no parent corporation and they share management, that sort of thing. That's another situation where you might be able to aggregate the employees from the 2 restaurants. I would encourage you, since this is a fact-specific analysis and it's a legal analysis, that, obviously here today we're sharing basic concept of this law, but you can't rely on specific things we're saying without analyzing the facts and circumstances of your particular situation. So I would encourage you to get legal advice if there's a question as to whether you can or can't aggregate and whether that's going to make the difference to whether you comply with the law. So that's something to keep in mind. I also have up here, again, this is from the joint employer regulation under the FMLA, if there's, sharing of employees at the different facilities and, if there's joint control. So it's some of the same factors that we talked about previously. You're going to want to look at those as well if you have multiple restaurants all sharing a pool of employees and having some joint or common ownership. Okay. So the family medical leave expansion we're going to talk about first. It amends the FMLA on a temporary basis, and it's through the end of this year. For all of you who are aware of FMLA and familiar with it, you know that typically it provides 12 weeks of job-protected unpaid leave for employees with serious health conditions or who have to care for others with serious health conditions and for various other reasons. So some of the concepts that we're typically used to under the FMLA are different here. So just this is something really to be focused on, because when most people think of FMLA, they think unpaid leave, and here there's some paid aspects to the FMLA. And there's also some confusion out there because originally the House bill that was passed had many more categories of paid FMLA leave, but not anymore. So make sure that if you're looking at the materials out there, you're not relying on outdated information regarding the House and their first proposal ultimately was modified, and then it was passed by the Senate. So there's an expanded definition of eligible employee. So you only have to be employed for 30 calendar days, and it doesn't matter whether you're full or part-time. It doesn't matter how many hours you have. So this is replacing the default requirement under the FMLA only with respect to this COVID-related paid leave. So, and we already talked about the alternative definition of covered employer. If you're over 500, you don't have to comply. There are a lot of questions from people. Why did they do it that way? Who knows? So this is the leave that people are entitled to, this COVID-19 related FMLA leave. And it's only for this reason. There's this one reason. The employee is unable to work or telework due to a need for leave to care for the son or daughter under 18 years of age of such employee if the school or place of care has been closed or the child care provider of such son or daughter is unavailable due to a public health emergency. So this is the only basis of this COVID-19 Emergency FMLA Expansion Act, okay? Obviously, school is defined as elementary and secondary schools, so we're not talking about our college-age kids. And child care provider, it's also important to note, is only a paid child care provider, not an unpaid provider, like a parent or relative that's typically taking care of the child. So that's another thing to be aware of. So whether the covered employees are required to provide whether covered employers are required to provide this paid FMLA leave depends on the length of the leave, right? Whether it's paid or unpaid. And there's some interplay between this FMLA portion and the emergency paid sick leave that we're going to talk about later. But just focusing only on this FMLA expansion, the first 10 days of the COVID-19 related FMLA leave are unpaid, okay? So it's job protected, just like any other FMLA leave would be, but it is unpaid. And then we'll look at the interrelation with the paid sick leave in a minute. And under this 10 days, an employee can elect to substitute accrued paid vacation, personal leave, medical or sick leave to the extent that the medical or sick leave is something that they would be able to use, that they are, sick. It's important to note that there's an interplay again with this Emergency Paid Sick Leave Act. So really the guidance on this slide is with respect to everything between now and April 2nd. Employers until April 2nd can require their employees to use any accrued leave during these first 10 days if they want to. Obviously, I'm sure there are cash flow issues here, and you may have to change your policies. You can change your policies if you need to. You just need to provide your employees with notice about that. But after April 2nd, the paid sick leave aspect of the law says you can't require employees to exhaust their paid leave. I know that people have questions also about what they need to do vis-a-vis their exempt or their non-exempt staff, and hopefully we'll have time to answer any specific questions people have in that regard at the end. So, from a practical perspective, this Emergency Paid Sick Leave Act, as of April 2nd, prevents employers from being able to require use of the PTO first. Again, I hope that the Department of Labor is going to provide some clarity here. So as it stands, though, this Emergency Paid Sick Leave Act, if an employee is eligible for it, you're going to have to give that first. And you can't mandate the use of the PTO beforehand. Again, after April 2nd, which is the magic day. So After the 10 days, so we've gotten past the 10 days, covered employers have to provide paid COVID-19 related FMLA leave at no less than 2/3 of the employee's regular rate of pay for the number of hours the employee would have normally been scheduled. Obviously, if you have employees who have the same number of hours, that's an easy thing. But if employees' weekly schedules vary, there's a formula that's in the statute that you have to use. You have to look at the last 6 months and the average number of hours the employee worked, and you calculate the 6 months immediately preceding the leave. If the employee's new, then you just have to look at what they're scheduled for. There are caps on this COVID-related FMLA leave, $200 per day and $10,000 in the aggregate per employee, because as you know, we're talking about FMLA, so we're talking about 12 weeks of leave. The first 2 weeks are unpaid, but then if it's a COVID-related reason, which as you saw is related to the care of a child under 18 who's out of school, then they're entitled to that 10 weeks of paid leave. And to the extent that it's foreseeable COVID-related leave, employees have to give notice. But, I think, schools are all closed at this point. So I think, you're probably, if you're covered under the act, you're going to need to put together some communication that's available to your employees so that you can share with them information and they can let you know what's required. So the restoration to jobs, it's similar to what you deal with traditional FMLA leave. So it's job protected and the employee must be restored to the same or equivalent position when they return to work. Obviously, if the positions are no longer available, there's a provision in the regular FMLA dealing with that. And then, you're just gonna have to cross that bridge when you come to it. There is a specific provision in the law that if employers have fewer than 25 employees, they don't have to restore employees who have taken this COVID-related FMLA leave to their same or equivalent position. And if you meet the 3 requirements, the position doesn't exist because essentially of the COVID emergency, the employer makes reasonable efforts to restore the employee to an equivalent position. And if there is no equivalent position, the employer makes efforts to contact that displaced worker if an equivalent position becomes available for up to a year. So it's sort of like a preferred right of recall. And again, that's only with respect to the 25 employees. If for employers with only 25 employees or fewer. If you have more, there's nothing specific in the statute, but I'm hoping again that the Department of Labor is going to give some additional guidance in that regard. Okay, that is a picture of the U.S. Secretary of Labor, Secretary Scalia, the son of former Justice Antonin Scalia. He's announced that the Secretary has authority to issue regulations to exempt small businesses with fewer than 50 employees. When the imposition of the requirements in this FMLA aspect of the law would jeopardize the viability of the business. So we don't know whether we're going to see these types of regulations. Hopefully, if we're going to see them, we're going to see them sooner rather than later. So if you are looking for that, I'm going to make sure that you have information to reach out to the Department of Labor. This is information from the Department of Labor's press release that they issued on March 20th. So the exemption, it says here, for small businesses with fewer than 50 employees will be eligible for an exemption from the leave requirements relating to school closings or childcare requirements, unavailability, where the requirements would jeopardize the ability of the business to continue. So again, this is similar to the language in the statute. So we're waiting on what he's calling clear criteria that make it available in certain circumstances. And so we're just going to have to wait for that emergency guidance and rulemaking to clearly articulate that standard. There's also, again, very positive that the Department of Labor has announced that they're not going to engage in any enforcement action for the first 30 days of the statute being effective, so 30 days after April 2nd. Of course, that doesn't stop private plaintiffs' attorneys from prosecuting actions under the statute. So it's nice the Department of Labor is going to focus on compliance assistance during that 30-day period, but that's not necessarily going to, and I don't think would protect you from a private lawsuit for noncompliance. Okay, so that ends the discussion of the FMLA portion of the statute. The second significant aspect of the statute that we're going to talk about is the Emergency Paid Sick Leave Act. Again, we're talking about employers with fewer than 500 employees. So if you have more than 500 employees, you don't need to comply. And again, we're borrowing definitions from other statutes. This Paid Sick Leave Act is borrowing a lot of the provisions of the Federal Fair Labor Standards Act, which is, you know, the seminal wage and hour law under federal law. So the Paid Sick Leave Act provides 2 weeks of paid leave for one of 6 qualifying reasons. Employee is defined as the same as employee under the Fair Labor Standards Act. So again, if you all are covered by the FLSA, then then that's what you're looking at here. And again, private employers, fewer than 500. This is a really important slide. These are the 6 reasons set forth in the statute that provide for emergency paid sick leave. And we're going to look at them in 2 different groupings because there's different treatment for categories 1 to 3 and categories 4 to 6. So, but these are all situations where employees covered by this act are going to be entitled to this emergency paid sick leave of 2 weeks. So the first 3 categories, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. And I'm going to get back to that in a minute because there's been a lot of discussion as to whether and to what degree the current orders that we have would qualify under number 1. Number 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Number 3, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So these are all related to risk created by or illness related to COVID-19. The next 3 are caretaking and a catch-all. Number 4, the employee is caring for an individual who is subject to a federal, state, or local quarantine or isolation order related to COVID-19 or has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Number 5, the employee is caring for a son or daughter of such employee if the school or place of care of the son or daughter has been closed or the child care provider of such son or daughter is unavailable due to COVID-19 precautions. So that's similar to the FMLA provision we talked about before. And number 6, the employee is experiencing any other substantially similar conditions specified by the Secretary of HHS in consultation with the Secretary of the Treasury and the Secretary of Labor. So going back to number 1 here, I know there's been a lot of discussion as to whether the governor's orders recently subjecting certain counties to stay at home and Mayor Kenny's order, people have questioned whether that trips number 1. Since there are exceptions and it's not a full quarantine or isolation order, so obviously people can leave their homes for life-sustaining reasons, to go to the grocery store. People who are working in life-sustaining businesses can go to work. So I think that a lot of folks think that number 1 wouldn't be tripped by the current orders. Obviously, the orders may change. So number 1 is a bit of a moving target, but I think that that the better argument is that right now, sitting here, you know, at 12:24 p.m. on March 24th, that we haven't tripped number one quite yet. Again, you know, you could trip many of the other ones, and since a lot of folks, you know, have kids at home and schools are closed for several weeks, they're gonna trip 4 or 5 as well. So so these are the 6 reasons for people to be eligible for the sick leave under the Emergency Paid Sick Leave Act. Employers can elect to exclude healthcare providers. So that's for, you know, our healthcare clients and emergency responders, which is encouraging because it means that they're not going to be incentivized to take paid sick leave. And this is an important thing to note. And, you know, it's the law of unintended consequences, I think. But an employer is not required to provide this paid leave to an employee who's subject to reduced hours or layoff or furlough because the employer's business has been impacted. So that's just something for you all to be aware of, and it may, you know, impact your thought process as things go forward. So the duration of the sick time. Full-time employees are entitled to 80 hours of paid sick time, so that's roughly 2 weeks. Part-time employees are entitled to the number of hours that the employee typically works on an average over a 2-week period. And, you know, just like the FMLA, there's a 6-month look-back period, or if the employee didn't work the prior 6 months, you're looking at the number of hours the employee was expected to work. So this is what's required. Employers are required to pay paid sick time at the greater of the employee's regular rate or applicable minimum wage. And this is, again, why I was grouping 1 through 3 separate from 4 through 6. If employers are taking this emergency paid sick leave due to reasons 1 through 3, employees are going to get 100% of their pay for those 80 hours. But if it's for reasons 4 through 6, employees are going to get 2/3 of their pay under the statute. And as with the FMLA Emergency Expansion Act, there are caps on the maximum paid sick time which employees are entitled to per employee. And for reasons 1 through 3, it's $511 per day as a maximum, with $5,111 in the aggregate. And for reasons 4 through 6, it's going to be $200 per day and $2,000 in the aggregate of paid sick leave per employee for those reasons. Paid sick leave is going to be available for employees regardless of how long the employee has been employed. So that's a distinction with the FMLA aspect. The FMLA aspect is 30 days. And in terms of existing paid leave policies, if you already have a paid leave policy, or if you are in Philadelphia and Pittsburgh and you have you know, paid leave policies that are mandated through those jurisdictions, you have to put this in a separate pot, right? And you can't obviously in those jurisdictions offer less than what's required legally. But if you're not in Philadelphia or Pittsburgh and you can, you know, make modifications to your existing paid leave policies, you can do that. You're free to alter your existing paid leave policies to help alleviate some of the impact of the act. You just have to do it in writing and give employees sufficient notice. And I'm sure that some employers are going to be doing that to try to manage things from a financial perspective. So sequencing. So obviously, the MLA Emergency Act doesn't kick in on a paid basis for 2 weeks. So you look at it in order, right? You look at the Emergency Paid Sick Leave Act first, right? In terms of usage, the Emergency Paid Sick Leave Act, and this is very important, makes clear that employers can't require employees to use their PTO before they use this emergency paid sick leave. So up until then, up until April 2nd, you can do that all you want, but starting on April 2nd, covered employers can't make their employees use their PTO or vacation time before they get this emergency paid sick leave. So you can do that until, but not after. And once employees have exhausted this emergency paid sick leave pay, and if they're not entitled to that FMLA pay, employers can require their employees to resume using their PTO or vacation if they want to get them paid time off. So another thing is there's a specific no preemption provision in this part of the statute. So it's very clear that the federal government is not looking to preempt any state and local laws like the Philadelphia and the Pittsburgh paid sick leave law. And if it's more protective, that essentially you're getting both reservoirs of paid leave. So you need to make sure that you're complying with both. I know that there was an article in the Inquirer today about the Philadelphia paid sick leave law. And I know that Melissa's been working on trying to get some clarification from Philadelphia as to whether and to what extent employees who are laid off need to be paid sick leave in Philadelphia, because, you know, it seems inconsistent because they're not going to be employed. How could they get that sick leave? But I think, you know, that's some clarity needs to be obtained from Philadelphia to get an understanding of what their position is there. Also of note, you can, as a condition of paying someone emergency paid sick leave, to require an employee to get someone to cover for them for their shift. And this is not a situation where this emergency paid sick leave can be carried over after December 31st of 2020. We're really looking at this as a short-term statute to provide some relief for employees in 2020 with respect to COVID-19. There's also an anti-retaliation provision of the paid sick leave law. So if people use it or file a complaint, and if someone brings a claim, they're going to be able to get the damages or seek the damages that are available under the Fair Labor Standards Act, both the FMLA and the FLSA, so both provisions. They provide private rights of action for plaintiffs to file suits. Those laws also provide for the payment of attorney's fees, and they also provide for potential individual liability. So that's not, I know that's not, it's not good news, but it's just sort of a fact of life. In terms of penalties, again, we're looking under the Emergency Paid Sick Leave Act to penalties available under the FLSA. So payment of what should have been paid, liquidated damages, and attorney's fees. So the Act requires employers to notify their employees of their rights by posting a notice. So notice on your website, that sort of thing, because obviously, you know, and at your physical locations for those of you who, you know, who have physical locations that remain open, you're going to try to post them conspicuously where you post other things. The Department of Labor is supposed to put together a notice, and they've indicated they're going to issue it on or before March 25th, which is tomorrow. And the Secretary of Labor, as with the FMLA provisions, he can issue regulations to exclude certain employers, healthcare employers, and also to exempt small businesses with fewer than 50 employees from providing paid sick leave under number 5. So number 5 is with respect to COVID-related family leave. So that tracks the same language as in the FMLA provisions. So I know when we're talking about these two acts, it's important to know what they provide, and they're all different and new to make sure that you're doing all the things that you need to do. But it's important to know that obviously the other things that you thought about before this Families First Coronavirus Response Act, they still exist. And it's a significant consideration, and you all, if you have to comply because you're under 500 employees, need to make sure you're doing what you need to do, but it's also really important to note that you have to assess whether and to what extent there may be some obligations with respect to employees related to laws that existed before COVID-19. So if you're covered by the FMLA, meaning if you have 50 or more employees within a 75-mile radius, and the employees are eligible for FMLA. So let's say the employee has a serious health condition, maybe the employee has asthma or diabetes or some condition that makes them more at risk for COVID-19, and they ask for regular old unpaid FMLA, right? Whether you're over 500 employees, under 500 employees, so long as the FMLA applies to you, you need to make sure that you are applying the FMLA appropriately to those employees, which means getting out the paperwork, designating the leave, so that then, and it's to everyone's benefit to designate the leave because that means it ticks away. But obviously, you're all doing the best you can, and those requirements, they're time consuming. So we're all just going to do the best we can. And if you have situations where you need advice as to how to go through that, I urge you to talk to legal counsel. In terms of the Americans with Disabilities Act, obviously if you're going to be covered if you have 15 or more employees, if someone has a disability and they ask not to come to work because of COVID-19, again, because they're at a high risk category, potentially, if the condition is serious enough, it could be that the person has COVID-19. That could be considered a disability. Probably not because it's of short duration, but it's severe. So, so make sure that you're thinking about those two acts. The Pennsylvania Human Relations Act applies to all employers in the Commonwealth with 4 or more employees and has the same requirements as the ADA in terms of disability discrimination. So that's an important piece applying to probably all of you because it's only 4 employees. And then, if you're thinking that you're going to have to lay off certain people or take other measures, you want to make sure that you're complying with all other employment laws. If you're doing a mass layoff and you're tripping up the WARN Act, you want to make sure that you're doing everything you can to fall within the exception in the WARN Act. So, and you also, if you're laying off certain people in specific job classifications, you want to document the reasons for the layoff and make sure that it's done in a way that tries to mitigate employment claims later on. Obviously, that's not your primary focus right now. Your primary focus is, making sure that the lights stay on. So, I know you all are going to do a lot of these things very quickly, but it's important to be aware of all of these moving parts so that you all can try to come out of this without legal claims on the other side. In terms of what I was talking about before, the Department of Labor is hosting a national online dialogue to provide employees and employers with an opportunity to offer their perspective. And I have the link on this slide 30. There's a Twitter chat, and then there's a website address. And so I urge you all, if you are looking for the Department of Labor to create that under 50 exemption, to make your voices heard and express, what it is that you're looking for in terms of the Department of Labor guidance. So I'm going to turn this over to my colleague Jim Malone for him to talk about the tax aspects.
Thanks, Andrea. Before we start delving into this, let's kind of focus on a granular level about what happens when you make payroll. Okay, you're required to pull taxes from the employee's wages. You're required to withhold FICA. You're required to withhold income tax, and then the employer has its own share of the FICA tax. Okay, So if I can show the next slide, this will give you a summary. What the Act does is it fiddles around with the employer's FICA payment obligations. Okay, so first of all, you're going to have, to the extent that you're paying employees who are on leave under either set of provisions that Andrea discussed, you're going to get a reduction in the FICA payment obligation. In addition, to the extent of those wages, you'll receive a credit towards your FICA obligations with respect to other wages that you're paying. But there's not going to be any change in your obligation to withhold employees' FICA or employees' income taxes. Okay? The other thing to bear in mind is this is a quarterly reporting system. So you're going to get a credit when you file the 941 return at the end of the close of the quarter. But you have federal deposit laws that, depending on your size, may require you to deposit monthly or more commonly twice a month. So there's going to be a lag there. We'll talk about the lag in a minute. So you've probably seen news releases to the effect that there's going to be no payroll tax liability for employees that are on leave. But that's not entirely accurate. The way that they did it, and it's a little convoluted, is FICA has two pieces. 6.2% piece that goes to Social Security benefits, a 1.45% Medicare piece. The 6.2% piece you're being relieved of paying, you still have to pay the 1.45% Medicare tax, but you're going to get a compensating credit to offset that. So that's the first piece, which is the reduction in FICA payments for wages paid to people that are on leave under one of these provisions. Now, emergency paid sick leave. You will receive credit for qualified sick leave wages, which are paid under the Emergency Paid Sick Leave Act. Added to that will be an allocated portion of your health plan expenses and the 1.45% Medicare tax credit. Okay. Now, this credit is refundable, which means that to the extent that your FICA obligations for a quarter are less than the amount of the credit because you have an enormous number of people out on leave, you would be able to apply for a refund. It is going to be included in the employer's income for tax purposes. So that is intended to prevent double benefits. And I think if you run the math, you'll find that that's true, but it's a little counterintuitive. Okay, the next piece. What are qualified sick leave wages? As you'll see, you see the same numbers that Andrea was talking about. You know, they're limited to 200 per person unless they fit in one of the first three categories, in which case they're up to $511 per day. Okay? Next one. Family leave. Similar structure, mirror provisions, and this is, can't read this slide. This is also refundable and again going to be included in your income. So, what's next? Here, it's a similar definition, and the caps are tied to the caps on the emergency family leave under the other provisions of the Act. Okay? Next, or is that my last one? Okay, there's one thing I should focus on, which remember I talked about how you make quarterly or your quarterly reporting, which is when your credits would arrive, but in the interim you're required to make deposits. The Act does not explicitly deal with that problem. What it does is it gives the Secretary of the Treasury authority to promulgate regulations that will allow it to waive the deposit penalties. Because normally, if you get in a pay period and you say, okay, I've got to pay this Medicare tax, but I'm going to get a credit for it when I file my return at the end of the quarter, you would be subject to penalty for failure to pay, ranging from 2% up to as much as 15%. So the parent thrust is that they expect the IRS to permit you to anticipate the credits that you will have as of the end of the quarter in making your deposits during the quarter. There hasn't been any formal action on that, but my sense is that the service is on top of this. I know that they requested immediate comments from the ABA tax section on the statute, and that those went out the door on Monday. So, you can't count on this being fixed right away, but I believe that they're going to be on top of it and relatively promptly. So that's really, the tax part of it is much simpler than the employment part, which is unusual. But please keep in mind that you've got to keep withholding income tax and you've got to keep withholding employee FICA. And those are trust fund taxes. So if you mess up on that, there's a prospect for personal liability. So please be careful with that aspect. And I think that gives us the tax and leaves room for questions.
Yeah. Thanks, Jim. So I see in the chat box that Melissa was asking to clarify how the law applies to businesses that have laid off employees. So my view on this, and absent additional guidance from the Department of Labor, is that if you've laid off an employee, the employee's employment has been terminated, right? They're not an active employee, that they wouldn't be considered for purposes of assessing whether they're entitled to these reservoirs of benefits. So I'm hoping that we're going to get some clarity from the Department of Labor on that. But if they're not an active employee as of the date that the law becomes effective, April 2nd, then I think my working assumption is that you don't need to provide them with these benefits. And then, ultimately, if you, recall or bring back the person or say, we'd like to rehire you, is probably the safest way to do it. Keep them say, we'll keep you on a list and we'll call you to give you a subsequent offer of employment, and you deal with it that way, then it shouldn't have any impact on the employees. In terms of making the presentation available, obviously, the recording is going to be available, and I don't know if you're going to make the slides available to the folks who listened and registered as well.
The recording will be in conjunction with the presentation. They'll be put together.
Perfect. Thank you very much. So if anyone has any additional specific questions about these, the provisions in the Emergency FMLA and the Emergency Sick Leave Act, or the tax implications, please let us know in the chat box and we can try to answer your questions for the remainder of the time that we have together. Okay.
Well, why don't I do this? Why don't I tell you a little bit more in a little more detail how your healthcare benefits payments are allocated for this purpose. That's one of the components of the credits. In other words, you get credit for the wages you pay. You get credit 1.45% of the wages, qualified wages, to make up for the Medicare tax that you're still paying. And then you're going to allocate your healthcare benefits. And this is an area where the statute sets a presumption that's going to proportion it, so that if I have an employee that's out on leave, for the number of days that they are out on leave, you would prorate the cost of their health insurance premiums over that time period, and you would get credit for that proportion. But the Treasury Department is given the ability to come up with different allocation methods, so we'll have to keep an eye on that. But I suspect that you're going to be in a situation where if you follow that baseline that's in the statute, you're going to be fine.
So one of the questions was, does the first 10 days start from April 2nd? Yeah, that's my working assumption as to what's going to happen. I assume that, again, the Department of Labor is going to make clear whether that's the case, but I would think that, you're counting the time as of April 2nd. Yes. And in terms of the other comment that you've laid off most of your staffs already, that's a challenging reality, and I'm not surprised to hear that, but it's a really challenging time we're living in right now. So someone asked, so in Pennsylvania, we were required to close the restaurants, so we laid our staff off, so we couldn't hire them because they wouldn't make the 30 days. Well, I'm not quite following the question. So someone is eligible for the FMLA aspect if they've been employed for 30 days. The sick leave law, you don't need to be employed for 30 days. It goes into effect on day one of your employment. So that's the answer to that question. I'm not quite following the beginning of the question in terms of layoff of staff.
May I ask you a question?
Sure.
If an employee states that they do not want to return to work because they're afraid of getting it, and we have provided all the safety measures, how do we treat that request of an employee?
Yeah, so I've gotten that question a lot the last few weeks, and I think just as you would any other request in a different circumstance, you need to ask clarifying questions of that employee to get an understanding of the reason. Because if the underlying reason is that the employee is afraid because they're immunocompromised because they have a certain medical condition, or if the employee is afraid because they have someone that they're living with in their household who is immunocompromised because of a medical condition, then you may have some obligations under the Americans with Disabilities Act or the Pennsylvania Human Relations Act to engage in the interactive process to try to accommodate the employee. And leaves of absence can be reasonable accommodations under those laws. But if the employee is expressing just a generalized fear, and it's not based on any kind of underlying medical condition, then you really have two choices. Choice number one is to say, look, these are all very trying and difficult times, and we're not going to try to make you come to work. Now, obviously, if you have limited people and you need people to come in, that may not be an option. But if the person is refusing to come to work and you have done everything you can to try to determine the reason why, you've given them all of the protective gear that you can give them, I mean, technically you could terminate them for job abandonment, but I mean, I don't know that that's necessarily what you would want to do under these set of circumstances. Obviously, if you're under that 500 number, and there are some considerations in terms of having that employee on the books as of April 2nd, which is unfortunate, but that's sort of the way I've been answering that question for clients. I don't know, do you have a follow-up question about that, or does that help you get a sense of the lay of the land?
Yeah, no, that helps. But my follow-up question is, so then if they are wanting to collect unemployment, are we able to then say, when unemployment sends us the questionnaire, that in fact work was available and they refused?
Sure. Yeah. Absolutely. Yeah. So with respect to unemployment, even if someone's just losing hours, they can apply for unemployment on the website. And there are some COVID related resources at the Department of Labor and Industries website. I'm sure you all probably know by now, they've waived the first week of the waiting period. They've waived the requirement to look for alternative work. But certainly if someone's refusing to come to work and they apply for unemployment, you know, it's factually accurate to tell them. Now, whether the Department of Labor and Industry is going to be persuaded by that, you know, who knows? The important thing to note is that the Department of Labor and Industry has made known that COVID-related applications for unemployment are not going to negatively impact employers' rating. So it may be a situation where if it's not going to impact you, that you may choose not to respond. So someone asked, does the act apply differently employees furloughed versus laid off? So there's not a reference anywhere to being furloughed. And, you know, when you say layoff, I think, you know, someone's, you know, they're terminated for lack of work. There's not a distinction that's created. I think that that's probably a real good clarifying question to ask to the Department of Labor. But as it stands right now, there's no clarity in that regard. So it's a really good question. So someone asked, I was just wondering if we could rehire them to get the benefits. Okay, so I answered the question. Okay. So if there's anyone else who has any more questions, feel free to put the questions in the chat box and we're happy to try to answer them. I know that, you know, a lot of our clients are challenged by a whole host of wage and hour type issues in addition to these issues, and, you know, questions about people coming to work and coughing and what do you do and how do you deal with it. So there's a lot of things that I know you all are navigating as employers right now. I know it's a real challenging environment, so we're here to help you with that.
Well, I don't know if we have any other questions. As I said, I will make this available, the slides available with the recording connected. It probably will take a few hours today for us just to get all the pieces put together, but it'll be available later on today, I believe. Andrea and James, I appreciate you taking the time today to get on and put these slides together and present this information to our members and the individuals that have gotten on the line. I know that the information is invaluable to them right now. Oh, wait, we have one more question.
Someone says, I heard that furloughed means employee is being paid 1 day per week in order to be able to retain them. Is that accurate? So I'm not sure where that comes from. I'm not aware of a specific definition of furloughed under this law or in general that apply. So I'm not sure where that comes from. I mean, obviously, you can retain an employee on the rolls and just have them not working actively. And so the question under that set of circumstances is, would they qualify as an employee? I think, you know, hopefully the Department of Labor will give us some clarity on that as well. But I'm not aware of that specific situation in terms of the furlough. Someone says we have employees still on payroll and healthcare, but no hours, right? So, you know, I know that some employers are continuing to do that, and I really do hope that the Department of Labor will provide some clarity as to whether those folks are going to be eligible for these benefits. I think, you know, if someone qualifies as an employee, then I would think, and your business has fewer than 500 people, then I would think they would qualify and be eligible for some of these benefits.
It actually might be beneficial in that circumstance to, if you've still got them on payroll and they're not working, you might be benefit for if you can qualify them for either sick leave or family leave because of the tax side of it.
I mean, I think the question, Jim, in that regard is a cash flow question, right?
Oh,
because they're not going to get the money back until the end of the quarter or the end of the month is what you were saying, right?
Well, I expect that to see the government fairly promptly take the regulatory authority it's been given and allow employers to assume that they're going to get the credits when they make their deposits. But that's just not the state of the law as I'm standing here today talking about it. So
Yeah.
right now you've got a cash flow lag built into this. Certainly the joint press release that came out from Labor and from Treasury suggests that they are, moving in the direction to make this as quick a cash turnaround as possible. But they've got to do something about the deposit penalties. Otherwise, people are going to get hurt.
Yeah. Hopefully we'll see some action on the part of the IRS, because I think that the longer we wait for guidance, the more employers are going to feel pressure to do things that they really don't want to do, because
That's absolutely right.
Because the incentive structure that's been created, which it's a shame, it really is a shame, but I understand that business owners are faced with really difficult decisions right now. And so hopefully we'll get some clarity that will help them very soon so that they can assess whether they should be keeping these folks on the rolls.
That's a fair synopsis.
Yeah. Okay.
I think we're at the hour mark, and I don't want to keep you guys too long because I know you have things going on in your own at the post and Schell. But again, thank you so much for taking time today to talk with our members. We will make this available. If you have additional questions after we get off the webinar, we do have a submit your question feature under our coronavirus page, so please feel free to use that to send us questions. And thank you again, Andrea and James, for getting on the call with us.
Thank you. Thank you very much, Hope. We really appreciate the opportunity to partner with PRLA, and I wish everyone on the line good luck in managing these challenges.
Thank you. We do too. Be safe, everyone, and have a great day.
Take care.
Bye.
Bye.